We are live.
Good afternoon and welcome to the next meeting of the Cannabis Control Commission. Of note, this is our third, the second for Commissioner De La Bata, or third for Commissioner De La Bata and myself, and second for Commissioner Wilson. All inside the first month. Today is my 1 month. That's hard to believe. But thrilled to be here. We have a lot of business to get through, so I'm going to jump right into it. Call to order, recognizing a quorum of the commissioners. I call the June 17th, 2026 meeting of the Cannabis Control Commission to order. This meeting is being held remote pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioners Delabato, Wilson, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a full agenda today that I will generally summarize. We will start with opening comments from the commissioners, followed by a vote on meeting minutes, then the executive director and commission staff report before we proceed to staff license recommendations. There are 2 change of ownership recommendations and 2 enforcement actions. Please note that the enforcement actions listed as item 4 on the agenda will be taken out of order and addressed immediately following the executive director and commission staff report. We will then proceed to staff recommendations on change of ownership, followed by commission discussion and votes. There is 1 item under discussion, under commission discussion and votes, Chapter 65 of the Acts of the 2026 regulatory package. For those that tuned in last week, this is the follow-on to the emergency regs that we had discussed last week. I'll ask that the commissioners wishing to comment or ask questions during any part of the meeting raise their hand to be recognized. All right, so why don't we start with commissioners' comments and updates, and I will start with Commissioner De La Bata. Any thoughts?
Excited to be here, meeting 3. Also, what is this, 3.5 weeks? So we've hit the ground running, working great with the team, working great with RED and general counsel and team. So excited for today, lots more to come, and I will turn it back to you, Chair.
Thank you, Commissioner, and over to you, Commissioner Wilson.
I don't have much more to add. So very similar to Commissioner Delabato. I will just add, and this, I think this will come up during the discussion, is I've been chewing on some of the things that we discussed at our last meeting. I think we've been having very productive conversations and really getting to some issues.
Terrific. Thank you, Commissioner. Appreciate that. Okay, our first item of business is the minutes for approval. And it's 1 set of minutes from our first meeting, which was the May 28th, 2026 public meeting. And if we have those up, now I know we have been provided those minutes in advance. I did have a chance to review. Any questions or comments from either of the commissioners? No. All right. Do we have a motion to approve?
So moved.
Do we have a second?
Second.
And roll call, Commissioner Delabato.
Aye.
Commissioner Wilson.
Aye.
And Chair Harding, aye. So moved. All right. With that, I'm going to move it over to the Executive Director and Commission Staff Report.
Thank you, Mr. Chairman. 2 of these reports that were going to be given to the commissioners for general information on process were on last week's. We moved them to this week, and you'll have the Enforcement Council, First Assistant Enforcement Council provide general updates for reports related to enforcement actions and some of the things, especially assessment of fines, that will be relevant. Later on in the agenda, we'll have enforcement actions for you to review. With general counsels here as well to represent the board in that discussion. So I think it'll be timely and set the table for you all coming in as in your adjudicatory role. So we will start with those 2, but it will flow nicely with the rest of the meeting. And I will turn it over through the chair to our enforcement counsel who will go through 1 of 2 presentations that they have teed up. Mr. Chair.
You enforcement. Or my button on. Over to you, enforcement counsel.
Thank you, Mr. Chair. Thank you, Executive Director. So we have 2 brief presentations just to update the board on a couple of projects that we have been working on. The first one, which First Assistant Enforcement Counsel Jacob Nielsen will be presenting on, is relative to the shelf audits to confirm potency accuracy, or labeled potency accuracy. And then I will go through kind of our new process for assessing the initial fine assessments when we identify a violation. So with that, I will pass it over to Counsel Nielsen to speak through the potency inflation bulletin update.
Mr. Chair, if I could just interrupt for a second.
Yes.
Our agendas aren't always in the same order as the, what's my words, the, whatever the top, the summary where all the things are. So what page of the packet are we on?
I think right now we are just on the agenda, but we are about to go into the potency inflation. So I've got that. If I go through the most recent packet. Yeah, I got to scroll down. I'm not sure which page that is unless anyone else can point that out.
So if you go into the PDF for the
Yeah.
board specific version with some of the confidential materials from council, and you go on the right, you can look at the bookmarks. And so if you flip down to the bottom, there are the presentations on these under commission discussion, excuse me, on the PowerPoint. And then the PowerPoint will be up on the screen as well.
And is there a page associated with that? I hear you too, but I'm with Commissioner Wilson.
Page in that PDF
In our 681 page pack.
is 658 is where the presentation starts.
Okay. Good question, Commissioner Wilson. And I just got there myself.
And
Thank you for bearing with us, Enforcement Council.
of course, and Mr. Chair, we also had included in the general public meeting materials packet the text of the bulletin that we are referring to as well. So if it would be helpful, I can share a link to the commission website in the meeting chat. So you will.
That would be helpful. Thank you.
And if sorry, Mr. Chair.
Yes.
So where I'm at is, I'm on page 666 in our packet. And it's, the title of the slide is Auditing the Accuracy of Label Potency. Is that what we're discussing? Okay.
Mr. Chair, may
Go right ahead.
can I get the next slide, please? All right, one more slide. All right, thank you. I'm Jacob Nielsen. I'm the First Assistant Enforcement Counsel, and I'm going to talk through some of our efforts in addressing THC inflation and our practices that we have started in auditing the accuracy of label potency. So starting in May of 2026, the Commission initiated a program to audit the accuracy of label potency for marijuana flower products available to consumers and patients. We started this initiative really to address the regulatory requirement that you can see up there, and that is that all marijuana flower is required to be labeled with information that includes the full cannabinoid profile of the marijuana contained within the package, including THC and other cannabinoid levels. So consumers and patients, they really rely on the information that is contained on a label, and in many cases, they make purchasing decisions based solely on the label potency. Licensees also rely on the information that's contained in the label or in a certificate of analysis that is provided by a laboratory, specifically relating to that potency piece of it when purchasing wholesale. And they generally will charge more for products that contain a higher total THC content. When a label is inaccurate, consumers are not getting the products that they are paying a premium for, and patients aren't getting the medicine that they expect. I believe Commissioner Wilson brought this up at the last public meeting in talking about potency and really what consumers are doing when they're making purchasing decisions. So the Commission started this program to regularly check flower products that are on shelves to ensure.
Hold on one second.
There's one.
Apologies. There we go. Got it. Sorry, just wanted to have the slides up and running.
To ensure that product on the shelves, to ensure that licensees are not falsely advertising and marketing products when they're selling, and to ensure consumer awareness. For this program to actually have an impact on public health and safety, we needed to establish a compliance standard for when the department would act against a licensee for an inaccurate label. So I'm calling back to the requirements that the label contain that full cannabinoid profile. So the standard that we landed on is the standard that you can see at the bottom of this slide, and it's that marijuana flower products that are audited and test within 75% to 125% of the labeled total THC will be considered to have an accurate label. So that standard, and I'm going to refer to the 75 to 125% as plus minus 25%. It just makes a little bit more sense in my head. It'd be similar to like a polling accuracy. So that's what we're talking about with potency. So that standard, it accounts for the fact that this product is a plant and it can't be made perfectly homogeneous. That's different from a concentrate product, which you do have the ability to make that homogeneous. And what academic studies have shown is that one part of the plant may have a difference in potency from another part, and that is impacted by a number of factors, which includes growth during cultivation, storage conditions once packaged, and the reality that potency of this product does actually degrade over time. I'll briefly touch on one of the studies in a little bit regarding that. But what we tried to do with this compliance standard is to account for those factors and establish what we believe to be a reasonable expectation for all the parties when we are carrying out these audits. So to give more of like a real number example, if we have a product that is labeled as having a total THC value of 15%, then the acceptable range of results during an audit would be from 11.25% total THC to 18.75% total THC. A result outside of that range would mean that the label is non-compliant. So in determining that compliance standard, we look to a couple of areas. One, we research what are other jurisdictions doing in enforcing their own potency and labeling standards. A couple of states will have a similar plus minus standard. Some of them will have 10%. Some of them have 15%. Arizona has a plus minus 25% range. And other jurisdictions, when we're talking about the potency of marijuana flower, they actually might have a hard cap on any marijuana, like you can't sell any marijuana flower above 30% total THC. That's not what we've proposed here, but that is just kind of the realm of what we have going on. We also looked to journal articles and academic studies on the topic of accuracy of cannabis potency. A couple of the studies found that, one study from 2025 found that in 178 flower products, 43% of those fell outside of a plus minus 15% range, compared to concentrate products, where 96% of them fell within a plus minus 15% range. Two other studies from 2023 and 2024 found that 70% of flower products from dispensaries in a number of states that were in that study, 70% of them fell out of a plus minus 20% range, and that the average total THC of a reported label could be inflated of up to 30% above what was actually in that product. So potency inflation is something that is well researched. It is an issue that all jurisdictions are dealing with, and this is our attempt at auditing this issue and identifying what should we be doing about it. So for our purposes, and before I move on to the next slide, because I know I've stayed on this slide for a little bit, we actually conducted a testing study of our own in 2025 of 4 different marijuana strains that we submitted numerous blind samples of those 4 strains to all of the ITLs. And that was really for us to get a baseline to see what would we see in a range of a single product tested by all of the laboratories. Overall, the commission submitted 228 samples for testing. Can I get the next slide? So this slide shows an example of the testing results for one of the strains. And I'm going to go through the information that's contained within this slide. So the black line that you'll see in the middle of the graph is the actual labeled potency, labeled total THC for this specific strain. The red shaded areas represents results of tests that fall outside of plus minus 25%. The yellow shaded area is between plus minus 15% and plus minus 25%. And the green shaded area is between plus minus 15%. And then the last information you'll see on this slide is that a light blue line, and that represents the average. Here in this study, what we found and what we identified is that there is going to be a range. Again, this is a product that cannot be made homogeneous, so we are going to see a range. There were a couple of results that fell outside of plus minus 25%, and we actually included that in how we are going to identify if there is a deviation. I'll talk a little bit about that later, because one single point can be an outlier, so we want to make sure that we're taking that into account. And interestingly here, we would actually, looking at the average, this product was perhaps slightly under-labeled compared to what we might see on average. So it shows really that potency inflation is not always necessarily the thing. There can be some deflation, but in most other of the examples that we had, there was more of an inflationary aspect to it. Can I get the next slide? So I'm gonna just briefly touch on our auditing process. So right now, our secret shopper program, what they're doing is they're going out to dispensaries and retailers, and they are purchasing marijuana flower that is available for sale and on shelves. They're then taking those marijuana flowers and sending that to the ITL that originally tested the products. We are doing that in the absence of a state standard lab. That would be the gold standard. If we can just say, hey, we have complete control over the testing results, we're just going to send all of our auditing samples there. But because we don't have a state standards laboratory right now, we felt that using the ITL that originally provided the testing results that are appearing on the package eliminates some variables and may eliminate some of those challenges that we would receive, especially if there's a claim of, oh, we're picking and choosing which ITL is actually providing those results. So we're just sending it back to the same ITL. When we are sending it to the ITL, we are eliminating any branding to the best of our ability on those products. It's a little bit harder on pre-rolls, but that is really to try to get a true blind sample that the ITL doesn't know what product that we're sending to them, what metric tag it came from. They're just getting a product, testing it blind. They're then instructed to homogenize the product to the best of their ability. So that typically will include grinding up the product because we're talking about marijuana flower. And they're taking 3 randomly selected samples for testing, and all 3 of those results are reported to the commission. And we are doing that really to eliminate, because what we'll do with the 3 samples is we'll take an average of that. So that's to try and eliminate any of the outliers. So we take the average of that observed potency, and then we apply the equation that you see on the slide to determine whether there is a deviation from the reported potency. And from there, all of the licensees that we audit will receive a notice. So regardless of whether it falls within that, if it is what we would say is an accurate label, they will get a notice. If it is an inaccurate label, they will also receive a notice. This is really part of our effort to provide as much transparency into this process. And in addition to that, we will be posting these on our website once we have an enforcement portal that will have the results of all of the potency audits and the notices that we have sent to the licensees. If an audit does determine that the potency of a product is outside of the expected values, that product will be put on an administrative hold pending further investigation, and the licensee will be notified that the marijuana product label is not substantially compliant, and an order to dispose of the marijuana is contemplated. That is consistent with one of our enforcement tools, which is the limitation on sales, and that's under 935 CMR 500-330. And what that standard requires us to do is first send a notice of the substantial noncompliance before we take any action, giving the licensee an opportunity to resolve that noncompliance. And then if they have not, then we're saying we're going to issue an order to dispose of that product. So they'll be notified of that. The licensee, they have a number of options that will be available to them if the label is found to be substantially noncompliant, and that is that they can voluntarily recall the product for relabeling. They can dispose of that product voluntarily, or they can further process it into a concentrate, submit it through additional testing, etc. The licensee can also challenge our results. If they believe that there's something wrong with the commission's audit, there's a process that is outlined in the notice that we would send to licensees where there is an inaccurate label, and they can follow that process and challenge the commission. So those are our efforts with attempting to address potency inflation and auditing the accuracy of labeled potency. This is where we are starting. We're really concerned with our ability to sustain this project, to sustain this initiative. So right now we're starting with potency, and then our next efforts will be to start addressing some other contaminants such as total yeast and mold, heavy metals, pesticides. We are going to get there, but we want to make sure that this program works first. And once we get to the other things, we'll try to address them as well. And we'll have to establish other standards, especially when we're like for potency, having that plus minus 25% makes sense, but that might not make sense for total yeast and mold, heavy metals, etc. So if you have any questions, I'll do my best to answer them. So yeah.
Commissioners?
I have a number of questions. So what to ask first?
You're probably going to ask mine, so that's a good thing. So you go and we'll see what's left.
Let me kind of walk through this a little bit. So first question, in terms of the testing, can you walk me through, again, outside of this project, what type of tests are marijuana product going through currently as it goes from cultivation to dispensary?
So our protocols require different testing at depending on what stage that they're at. I wouldn't say that I'm necessarily an expert on what exactly the tests are, but a full panel test will require testing for pesticides, heavy.
I'm sorry, let me just, I, I've been actually looking at this, so I'm kind of aware of.
Okay, sure.
I'm just curious about in terms of the supply chain, how often and when are the tests being done by the industry?
So the tests can occur during the following the cultivation process. So during the cultivation process, there we have testing for the growing material. That is one of the would be one of the areas where there would be a requirement for testing. And Tim's pulling up them to probably assist me in a second. But so we have that part. Once the product is harvested, cured, and dried, they will be subject to certain testing requirements that is also in our protocol. And then depending on how that product is processed, there may be additional testing. So for a concentrate, once the product is processed from just the marijuana flower, like a bulk marijuana flower, into a concentrate, there will be an additional layer of testing that would be required.
And is this, now there's a number of different types of tests. Is this the
Yes.
potency testing that we're talking about?
This is specific to potency, yes.
Great. And if we go back to the slide with the graph,
Sure. If you can just go back one, I think.
I just wanted to sort of make sure that I understood the graph, because I guess I heard two different things. One was we are taking finished product from the shelf and we are testing that. And two, I thought I heard someone say that we were testing the plant or what was harvested way earlier up in the supply chain. I want to make sure that I understand what has been tested based on the presentation and what has been tested and shown.
Right. So if we're strictly speaking to flower, that will have been tested earlier on in the supply chain. So a cultivator, they create a harvest batch and they have a source package of 15 pounds is what the packages are required to be. That package, they will be submitting a sample, representative sample is what they're supposed to be doing to a laboratory for results. I believe that's a full panel, but I might be mistaken on that. So my understanding is that that would be a full panel. And then that, when we're talking about just for potency, that would be the result for potency that is applied to that package. And then any other flower products from that package, as long as it's not further processed.
And not to cut you off before you go, my question is sort of squarely on our project. Are we testing flower that has been recently harvested, or are we testing final product, or both?
We are testing the final product of what is on shelves.
Yes, and Commissioner Wilson, if I may, so one item, just hearing what you're saying with respect to this chart and what we are doing or executing right now. So this chart was really part of the process which informed our compliance determination for the plus or minus 25%. So what we did with respect to kind of these initial baseline tests, those were utilizing flower that we received directly from a cultivator. What we are doing now, we have a focus on ensuring patients and consumers have accurate labels that they can purchase and inform their purchases on. And also with respect to patients in particular, inform their kind of medical dose of how they're using their medicine. So what we are doing now is a direct shelf audit or an audit of products that are contained on store shelves. At this time, that is our focus. I am not going to kind of exclude the opportunity for us to then directly go out to cultivators and perform some additional testing. We do have the authority through our regulations to require additional testing while we are out on an investigation or an inspection. And in addition, in areas where we, as the agency, may determine that additional testing is required to protect public health and safety, we can also do it in those instances too. So just wanted to, or hope that clarifies in terms of what we're looking at with respect to this chart versus what we are actually doing in practice right now. This informed the current practice.
And that's very helpful. And I asked, because there was a statement during the presentation, again, not that it was bad or anything. There was a statement that we tested a strain and we sent it to all the ITLs. When I hear strain, I'm thinking plant, I'm thinking pre-final product. So
if I'm not mistaken, these Commissioner Wilson, if I'm not mistaken, These were taken directly from a cultivator or a product manufacturer. There are some other aspects of why we were able to obtain those products for this baseline study. But yes, this was not an on-shelf product. We wanted to obtain a large mass of marijuana to see what we should be doing in establishing this range that would be acceptable. So it's the same product submitted to all of the laboratories to see what would we get from a variance of results from all the plants.
And I apologize, Mr. Chair, I don't want to be pedantic, but just for
That's fine.
those that,
This is very educational. Thank you.
and those that may be listening, just to understand, so there are two tests. There was a pre-project test. We want to do this project around shelf testing. So we want to get some basically raw material. We want to find what the potency ranges are for the raw material. That will give us a range to say, if we do the shelf testing, it should be within this range. Second stage, we grab some stuff off someone's shelves. We send that around some ITLs, and then we see if they fall within the range that we predetermined.
For Commissioner Wilson, for the second stage, it is the same ITL. We are not sending that to all of the ITLs. The product that we are obtaining off the shelf is only going back to the same ITL that provided the initial results.
And again, I apologize, Mr. Chair, if I'm taking time here. I was just curious, why send it back to the same ITL versus circulating it to a variety of ITLs?
So we wanted to eliminate, Commissioner Wilson, we wanted to eliminate some variables. And one of those variables might be, well, why is the commission sending my marijuana product to this other lab? Maybe that lab uses a different process for providing potency results. So to eliminate that variable, it's just going right back to the same laboratory that used this, hypothetically uses the same process that they used when they received the initial sample. And that was really our thought process there. And like I was saying earlier, if we had a standards lab, that is where I would want to send the samples. But until we have that, we felt that this was the best practice.
Could I just add, just to emphasize a point that Jake made here. So it's really what we are trying to do is, in the absence of a standards lab, we want to compare apples to apples. So ensuring if we send a sample back to the same lab that performed the initial compliance test, we are ensured that they are going to be utilizing the same processes, preparing the sample in a substantially similar way, et cetera. The ideal, like Jake noted, would be a standards lab. If we have that yardstick, which we are able to use to then compare all labs to, and then that is kind of our in-house state expert, or even not in-house, but our state expert in cannabis testing that could assist us with determining what that standard is, what our kind of gold standard would be for those tests. We would ideally like to use that, and perhaps there would be some conversations, I'm sure, with kind of labs or making sure that we're adapting this process to account for that new resource. But in the absence of that, like Jake noted, some labs may use slightly different processes or techniques in testing for the cannabinoid profile. And some of those little tweaks could have I'll say a statistically significant effect on the final potency that we would see. Like as just pointing at this chart here, you can see that all of these samples came from the same harvest or production batch, and we saw results that range from about 18% THC to about 30.5% THC. So that is a pretty significant range. When we're looking at the individual labs, we saw that those results were much closer together. And every individual dot here is a particular test performed by a lab, and each lab got, depending on the strain or package that we sent in, there was 3 to 6 samples that were sent. So we did receive a number of different results from each lab that we were able to inform our compliance determination using.
And then one more question. Before we move on to the next topic, I might have some comments after everyone's head around, but just the last question I'll have on this is for the notification. So the labels are put on by the manufacturer. Are the notifications going to the manufacturer, the dispensary, the cultivator, all three, some subset?
It would be the cultivator, the whomever packaged and tested that product. That is where the notice will go. So yes, it would have some follow-on impacts to retailers who are selling it, but our audit really is of who was responsible for those testing results. That's the licensee that we would be auditing.
I'll save my comments for the end of the thing. That's great.
Commissioner, any other follow-up questions?
Commissioner Wilson took my question about who receives the notice. So thank you.
That was also one of my questions. And you nailed a bunch of mine, but I do have one kind of overarching question, which is, are we looking for nefarious players or accuracy or both?
Mr. Chair, we're looking for both. There may be some nefarious players, as we have seen that there have been a number of complaints about potency inflation. We have done some audits where we have seen the label of the potency is 30%, and then the results of what is actually in the package is like 11. So that is something that we want to make sure that we are addressing. It doesn't necessarily mean that there was any specific bad actor. There could be other root cause issues, and that would be part of that further investigation. And what we're hoping that this does is that really set that expectation for, if I'm a consumer and I'm purchasing a marijuana product, I should have some level of confidence. So if there is indeed, in fact, some potency inflation, let's try to bring that back down to say, this is the expectation that the commission will have. And so if you are engaging in those bad practices, we are going to catch you, and this is how we're going to do it.
Go ahead, Commissioner. Oh,
Thank you, Commissioner. Just to kind of add on to that or supplement as well, I don't want to say that this, I think Jake is absolutely right. There is kind of an angle towards both of those areas. I think what our initial intent or our primary focus here is to ensure accuracy. We want to make sure that patients and consumers understand what they are purchasing and that those products accurately reflect, or the label accurately reflects what is inside of the package there. However, that being said, what we may end up identifying through this process is that perhaps cultivators or product manufacturers are not accurately taking representative samples for that initial compliance test. Perhaps there is a change in the actual product type that was not correctly reflected in metric or captured by metric. So there may, through this auditing process, obviously, making sure that the label is accurate, that is the first step, or the first follow-on step after the audit is performed and we get those results. However, following that, there may be a need to perform an additional investigation or at least speak to the cultivators, product manufacturers, et cetera, to try to identify what was the root cause of this discrepancy. And that is going to be part of the notices that we will be sending out. Like Jake noted, we're going to be sending out notices for anybody that is audited. So if somebody falls within an accepted range or an expected range, excuse me, we will provide notice to them. We will also provide notice to folks who are kind of on that borderline. I have been colloquially referring to these as our kind of green light, yellow light, red light system. So if you're in the yellow light, you will still receive a notice, and we will also in that notice identify that you are kind of on the borderline. You may want to consider performing a root cause analysis. Why did this change? And I do anticipate that we are going to have some communication with ITLs just to make sure that there isn't a lab issue that is going on. I will note the labs are testing the product as received from the cultivator product manufacturer too. So want to note that distinction as well. And like you noted, with the retailers, they are the ones that actually have the products on store shelves. They will have to receive a notice in terms of this product is being placed on administrative hold because it was subject to an audit and the label is inaccurate. So we will have to be in communication with folks throughout the production or that kind of chain there.
It begs another question, and one of the assignments that Commissioner Wilson's going to be taking point on around testing. And when I hear about different labs testing different ways, it begs the question, why? Why not have a standard? And again, not for today, but I know that's an interesting one, as we start to look at that, because as you said earlier, apples to apples.
Mm-hmm.
And it's kind of hard when you got apples, oranges, bananas, and, kumquats out there. So, and for another day, but Commissioner, you had another?
So that was actually Timmy, Neil, you spoke on it already on ensuring that's not a lab issue. Because my question is, if someone's in the red light zone, is there a lab that is consistently in the red light zone? That would tell me that we need to look at that a little bit more carefully to figure out what's going on there. And to Chair Harding's point, if we have 11, very, different testing labs, different processes within each, I'm assuming different technologies, there's discrepancy that will be there. So not a conversation for today. Yeah, so.
Very helpful. Very much appreciate walking us through, and very good questions, Commissioner Wilson, as well. We have another question?
Yes, Mr. Chair, I just want to make a statement based on some of the feedback we've had after an initial discussion of this. Obviously, the bulletin and all those things are in the packet, and you're kind of going through the logic with the team today. Some of the feedback I'd received previously was this means, since we're now focusing on THC potency, we're not focusing on public health and safety. So just want to make sure that it's understood. This is being built out for a variety of reasons. I think you've all gone through in your Q&A, but certainly, THC potency falls more in the category of consumer protection, making sure people are getting what they're purchasing. But total yeast and mold, metals, pesticides, and the things that fall more under the public health and safety impacts the workers in the industry, impacts patients and consumers is still very much a focus. This is not taking away from that, but this is something that we know we need to build in. And I think so far I've seen also just as feedback that this is a reasonable approach. From so far the feedback that I've got, I hope as you all are meeting folks in the industry as you get on board it as well, you bring any thoughts back that you get. But as of right now, I just want to make it clear to folks that yes, the THC potency focus falls more in the consumer protection area and addressing any concerns of consumer fraud. But total yeast and mold, metals, pesticides, the things that fall in the public health and safety, those are not falling to the wayside because of this focus. So I just want to make that statement as I promised individuals I would.
Thank you for that.
Just so, Commissioner, move on if I can just make a quick
Sure.
Go ahead. So I just want to say, again, I've sort of taken the lead on the labs and ITL topic. So first, I just want to say, great work. This is exactly what I think the commission should be doing at this right. And I want to just, again, we're not going to resolve this or making decisions at this meeting, but I just want to give a preview, a little bit of some things that I'm looking at. And something that particularly strikes me is that there's a lot of testing done basically right after harvest. And I've heard stories around particularly like cherry picking, which pieces of the harvest, we've got a bunch of regulations about how you do that. It seems to me like that is really the wrong place for the emphasis around testing. Our testing should be, because it is about consumer safety and that people get what they are buying, it should be near the end of the manufacturing process. When we've got a final product, we've got it in units that can be more easily procured really by anyone, whether it's commission staff of the lab, or staff of the licensee, to then go get it tested. And that, in case anyone doesn't know, there's actually a significant amount of time in the supply chain process after it goes from harvest to a final product that someone will consume. Even during the testing phase currently, it could sit in the cultivator for several days, if not weeks, prior to getting a result back to then move along the process. So that's a place for contamination that we're not having as much visibility into. And I think we should move our testing further down that supply chain. And that's something I'm looking at in terms of regulatory changes that may come down the line. So thank you very much, Mr. Chair.
You are welcome. All right. Unless there's anything further, we'll let you move on to your second topic.
Thank you, Mr. Chair. And I am up for the next topic, which will be an overview of our assessment of fines. And as a consumer protection agency, the commission is really focused on making sure that we are acting within our mission to safely and equitably ensure the kind of operation of the legalized cannabis industry in Massachusetts on the adult and medical side. And so utilizing fines or the assessment of fines in instances where we identify a violation of our regulations is one of our kind of primary tools here. Jay talked about some of the tools in his presentation, but our fines are really kind of one of the most standard ones that we utilize or regularly utilize. If we could go to the next slide, please. So I have a lot of general information up here that kind of describes the process that we took in developing this. But just as a baseline, pursuant to the statute 94G Section 4, and also contained within our regulations, the commission has the authority to assess monetary fines when we identify violations of our regulations or of the statute as well. In the regulations, those fines are capped at $50,000 for each violation. And also in certain circumstances, the commission may also assess a fine for each day during which a violation continues or per instance of a violation. So generally, we reserve those per day or per instance violations where we are able to actually categorize or break those violations up into those distinguishable days or instances. So historically, the commission did employ more of a two-tiered approach to our initial assessment. So we would look at violations and determine whether it was a minor violation or a major violation. And what we would utilize to kind of guide our assessment there would be the aggravating and mitigating circumstances that are outlined in our regulations under 935 CMR 500-360 and 501-360 for the medical regulations. So we did find that in our review, these did not always accurately consider the severity of violations at issue. So there could be some instances that it would still be considered a minor violation, but we would have a wide range. So for example, a kind of more systematic technical violation versus which could be like somebody did not add a written warning to an employee personnel file, that being assessed at the same rate as a kind of more egregious violations too. So what we did in terms of kind of developing or proposing a new approach to this, we did look at several other jurisdictions and we spoke with them. We performed a jurisdictional survey of their regulations to just kind of do a compare of what we are doing internally here. And we spoke with other folks in other jurisdictions too. And where we landed and what the commission has been utilizing based on the internal guidance is we have first taken a categorized approach to evaluating each violation, and I'll get into the categories on the next slide. And then we perform our initial assessment of those fines based on those distinct categories. We are also utilizing a progressive assessment strategy. So if there are repeat offenses within a certain period of time, we're looking at 3 years, we will escalate those penalties. So we have the states that we looked at when we were performing this review. We reviewed regulations in Colorado, Oregon, Vermont, Washington, among some others, but those are the ones that primarily informed our recommendation here. We also spoke with colleagues out in Arkansas, Connecticut, and Nevada as well. And what I will note is that and this was also very apparent going and attending the CANRA conference last week too, but different jurisdictions utilize different means to actually enforce regulations. Some states utilize or rely on the Attorney General's office. Some states, similar to Massachusetts, have internal enforcement counsel that can prosecute through the administrative process. There is kind of a wide range across jurisdictions. And that is similar, I think you will all come to recognize if you don't already, that the cannabis regulation and the approach is definitely varied in other jurisdictions, but oftentimes we're working on a similar sort of problem. So this was very really beneficial conversations to have as we were kind of developing this approach. And we are hopeful that utilizing this approach will increase efficiency when my team is actually performing those initial fine assessments and calculations. And then also working with our Director of Digital and Creative Services, Emery Burt. Like Jake alluded to, we are developing an enforcement portal, which will contain a lot of information that we would generally put out, including kind of stipulated agreements like we will hear later on, as well as we are planning on adding this guidance to that portal so that we are being transparent. Folks are able to identify what the different categories are, and then also what our internal guidelines are for assessing fines based on those violations within the number of years. Can we go to the next slide, please? And so on this slide, you'll see the 4 different categories that we are now utilizing. And I will say we did not come up with all of this language ourselves. We are definitely borrowing from other jurisdictions just to make sure that we are kind of moving forward with a process that does make sense generally and one that is sustainable as we move forward. So category 1 violations, those I'll just take them from category 1 down to category 4, which is really moving from the most severe to the least severe. So category 1 violations, those are violations that create a direct threat to public health, safety, or welfare. So there are generally multiple aggravating factors when we are looking at these violations in this category. And they also present a or they have directly impacted public health, safety, or welfare. So when we're thinking about these violations, just as a couple of examples, we could think of significant or repeat marijuana diversion or inversion, so that there is a large quantity of plants that are moving out of the building or moving into the building, or there is a high volume there. Potentially destroying or concealing evidence of a violation. So if we are involved in an investigation, if somebody or a licensee is trying to obstruct our ability to properly investigate, perhaps that is not initially category 1 violation, but once that is being concealed, that really stands in the way of the agency from performing our legitimate statutory duty. So that is something that we would treat seriously. And then I would also say some statutory violations, so such as a control violation, we would want to move forward with considering that as a category 1 violation, because that does have equity implications, particularly when we're talking about the cap there, and then also just kind of overall fairness in the industry as well. Moving on to category 2 violations. So these are violations that create a potential threat to public health, safety, welfare. So they may not be as severe as those violations that we see in category 1, but what we are looking at is that perhaps these are a violation that fall under 500-450 or 501-450. That section of our regulations identifies areas or grounds that constitute, or those are violations rather that constitute grounds for suspension, revocation, or denial of a renewal application. So those are very severe violations as determined by the agency and promulgated in regulation. But what we are also looking at here is these are potentially lesser violations, but they've been going on for a longer period of time, or they have been repeated and they could have an impact on the public health, safety, welfare. So we would see this in circumstances where there may be a public impact, but we have perhaps caught it early enough that that has not gone out to the public. So some examples in this category as well could be systemic sales of product with expired test results. If we were able to go, and I will note too with any of these, if we are able to determine through our investigation that perhaps initially we look at this as a potential threat to public health, safety, welfare, but if we go through the investigation, we do determine that there is an actual direct impact, we will still escalate or make sure that we are assessing this based on the higher category. Another one might be the intentional failure to take representative test samples. So just as we were talking about, the representativeness of the test sample is critical to ensuring that the label is accurate. If we are identifying that folks have not taken representative samples, there is a potential impact to public health, safety, welfare. Failing to take a representative sample could indicate that the plant or the product is contaminated. However, there may not be that implication. So without further investigation, we would generally look at this initially as something that would create a potential threat to public health, safety, welfare. Moving to category 3, and this one is kind of a little more squishy than the rest of them, but this is one of those areas where we have pulled this language from other jurisdictions and it has been proven effective in those other jurisdictions too. So these would be violations that create a climate conducive to abuse and non-compliant operation. So they're more severe than a routine operational violation, and if not addressed, they could create a potential direct threat to public health, safety, welfare. So for this one, we're looking at perhaps failing to maintain best cultivation practices. So that may lead to contamination. And really what we're hoping is that if we find these problems early enough, that will stop the escalation of these problems. Similarly, failing to train employees or having a pattern of failing to follow internal SOPs. Those could also be items that could potentially lead to or create a climate conducive to abuse or non-compliant. And then looking at our fourth category, these are routine operational violations. So these are generally kind of limited to the licensed operations. They have extremely limited or no impact on the public. And so with these ones, when we're talking about efficiency, really we would love to make sure that we're able to catch these violations sooner, take an action if required, and then resolve that matter and bring the licensee into compliance so that we can have that kind of effective partnership moving forward. So these ones, like I said, routine operational violations, say the licensee lacks the proper signage or camera coverage, something along those lines, where we would be able to identify and address that more quickly. So like I noted, we are kind of internally looking at these and capping where we are assessing those violations. So just as a general matter, and like I said, these are kind of internal guidelines. So if and we will post these for transparency's sake, but I do want to emphasize that these are not hard and fast rules. There needs to be some flexibility so that we can take into account the specific facts and circumstances with any of these matters. So for category 1 violations, we are looking at retaining that $50,000 cap established in regulations, making sure we have access to that full amount for those most severe violations. We would also potentially consider a suspension at that time, whether we're talking suspension of the license itself, or if there is any kind of individuals involved, a suspension for kind of personal accountability there. For category 2 violations, we're really more looking at kind of half that amount. So capping the fine assessment at around $25,000 for violations there. And also potentially considering a suspension if we are actually identifying that there is that potential threat or that was intentional as we were moving forward there. For category 3 violations, we're looking more of like a $15,000 cap for any of those violations. And then for the routine operational violations, we would intend to cap that around $1,000 for any of those. So as I noted at the beginning, if we are seeing repeat actions or repeat violations within a 3-year period, we would escalate those, and we can escalate them either by increasing the category. So like I said, if there are routine operational violations and we are seeing a repeat or a systematic violation there, that may now be viewed as a category 3 violation because it has now created a climate of non-compliant operations. So we would want to take kind of a progressive approach to that, where we are starting off by engaging with the licensee, trying to bring them into compliance. If that is not working, perhaps we will have to assess a fine. And if perhaps that fine assessment initially does not work, we will need to increase the penalty there. So in general, that is kind of the approach that we are moving forward with. We will publish this information on our website with the assistance of Director Burt there. And we will look to just make sure that this process is sustainable as we are moving forward. So we may have to look at certain processes, adjust or tweak some of those figures as we're looking through and assessing. But thus far, this has been working out well for us. But happy to take any questions if you might have.
Thank you very much, commissioners. Any questions?
Yeah, I have just
Commissioner Wilson, go right ahead. I have a couple as well.
so. First of all, thank you for the examples. That was very helpful in terms of thinking about the types of things that fall in these categories. I feel like we're conceptualizing it. And one of my questions that I crossed out was, what are the fine amounts? So you answered that in your presentation. Thank you.
With anticipating questions. That's
Great, great. You know, actually, one thing I wanted to say, I meant to say this in the previous section. If possible, you know, you're doing a lot of research looking at other jurisdictions and other industries. If you could maybe post a list of the citations for that research, that would be helpful for me. I think for the public, if we could put that in our agenda. So I just request that in the future. The only real question I had was, these are sub-regulatory changes. For example, they're like policy changes. There's no regulation required. I just don't want to cover that.
Thank you, Commissioner. And so with respect to any regulations, I would definitely defer over to our friends in the legal department, general counsel. But also what I will note, just as we were developing this, we did want to make sure we were acting within our existing regulatory authority. So the regulation right now says that we can assess a fine of up to $50,000. So we are still working within that range. But with respect to any kind of potential regulatory updates or anything along those lines, I would definitely defer over to the general counsel.
Yeah, General Counsel, unless I'm missing out, I guess from the presentation, I understood that they were going to move forward and that there was not a regulatory packet coming toward us on this item.
That is correct, Commissioner.
And I actually think that's really a good thing in terms of flexibility, because as you're saying, you know, move things up the escalation ladder in terms of the category. This provides the flexibility because some people are making a good amount of money, and you know, they may not be hurt by $1,000 and let this thing go on a particular violation. So I think that's great. I'll stop here.
Thank you, Commissioner. One question, not going to hold you to this. If you look back at the last 12 months, how many would you have in each category, in each bucket? Just rough sense.
Generally, Chair, I would want to have to go back and look at what we had in the past.
Yeah, I knew you were going to say that.
Sorry, I am a lawyer. That is
And if you're more comfortable doing that, that's fine. I just didn't know if you had looked at it and had a sense of, well, we had 3 1s and 4 2s and 5 3s and 7 4s.
it's a bad poker hand.
It would be interesting to know though, you know.
Absolutely. And we're happy to kind of look back into that. I know we did look into that when we were first developing this recommendation as well. So we did kind of compare what our fine assessments may have looked like if we were utilizing this. That was more so just to inform our own process, but happy to have a conversation with you offline or follow up separately, just in terms of kind of looking at what we have been assessing or our recommendations as well in terms of the assessments now, so that you get a bit of a sense of that.
Yeah, if you wouldn't mind sharing that with the commissioners offline, I think that'd be great. Just to give us a sense. I mean, you know, are we seeing 2 or 202?
Yeah.
That's for myself. I would like to know that. Oh, Commissioner has a question.
Just a quick question from a technical perspective. When would this practice of standardizing begin? Since that's not the current practice right now.
Thank you, Commissioner. Oh, sorry, Mr. Beer.
I thought I heard you're already doing it like this. They are.
Okay.
They've already started. Yeah.
Yes, and so this presentation really is to primarily inform you all as new commissioners here, also just kind of publicly discuss this as well for the benefit. And this was intended, this presentation we have been planning on since roughly March when we had conversations with the previous Board of Commissioners. What I will note as well is because this is internal, this was went through the process with the former Chief of Investigations and Enforcement, also Executive Director, in terms of signing off on this direction. So we have been utilizing this approach throughout this calendar year. And we have found, I will also note too, and this is not directly on point with your question, but you've reminded me, and I think this is a beneficial point to emphasize here. This relates to the initial assessment of any fine that we would be seeking at a hearing. So, for example, we're going to be discussing some stipulated agreements that are before the board for consideration today. The amount that is reflected in a stipulated agreement, that is following an informal dispute resolution conference. There was a negotiation. So the initial assessed fine very likely differs from what is reflected in that stipulated agreement. If we were moving forward to a hearing, the initial assessed fine is what we would be seeking. That is what is identified in the order to show cause, to say the commission has identified violations 1, 2, and 3. For violation 1, we view that as a category X violation, and we are assessing X amount as a penalty. And we would do that for the subsequent counts as well. So licensees, when they receive an order to show cause, that formal enforcement document, they do have access to this information. We are being transparent in that sense with the licensees too, as to what our calculation was. But a stipulated agreement might differ as well.
Thank you. And you anticipated other questions I had, so thank you.
You did. You're getting good at that. You're starting to read us well. Thank you. Unless you have any further thoughts on those 2 topics, I think we're prepared to move on to the next, which is, correct me if I'm wrong, ET, enforcement actions. So with that, you know what? We are going to take a 10-minute break and we'll be back at 1:15 if that's amenable to the group. So 10 minutes. We'll see you back here. All right, we are officially back. Thank you for everyone's patience as we took a little break. We'll see how far we can get and if we need to take one more, but at this point, we want to jump into enforcement actions, and I believe Enforcement Council is going to kick us off.
Thank you, Mr. Chair.
Over to you.
So just generally, I think it might be beneficial before we kick off into the two particular agreements before the board for consideration today, just to do a kind of broad overview of the investigations and enforcement process that led up to this point, just for edification of the board as well. And then I can get into a little bit of kind of the scope of stipulated agreement, what we're looking at with that too, and kind of the carry-on effects from any of the penalty that is collected or anything along those lines.
One comment, and you'll get to know me better over time. Absolutely, whatever you need to say, you say. Now, with that said, when I ask you what time it is, don't tell me how to build a clock. Tell me what time it is. So anyway, just so you know my mindset, you don't need to go 100 feet deep, maybe 10. But again, your judgment on what you need to present. So again, this is just, we're all kind of getting to know each other here. So
Yeah, absolutely.
that's how I think.
I appreciate that as well. I'll keep this just very high level too, just so that I'm giving a little bit of background and then we can kind of jump right into these specific agreements. So just as a broad overview, any of these matters will have been initiated through an investigation. That investigation is begun through either a complaint that we receive, if we identify something on an inspection, a routine inspection, through metric audits, et cetera. Our investigations team, and depending if it's our testing team, et cetera, too, they will engage in just a general due diligence review and investigation.
Could it also come from an outside referral, you know, someone calling into a tip line or complaint line or anything? I don't.
Yes,
all those.
Okay. Yes, absolutely. And so that would be kind of the initiation. And as well, I know the agency is in the process of developing that complaint resolution administrator position too. So that would be another area where we would be able to receive these. We do oftentimes receive complaints through the general inspections inbox as well, or through the general commission at CCC inbox too. And we will follow up on those as needed. So our investigations, testing team, et cetera, they will perform a actual investigation. They will complete a due diligence review, interview folks, perform additional metric audits, et cetera, at times coordinating with external partners as well, if we needed to do that, or if the circumstances warrant that. Also, there is internal collaboration. My team will at times serve as attorney advisors on any investigation, and that is really primarily in instances where there is a more complicated or complex matter, and we want to ensure that the investigation as it is progressing, we are one, keeping each other informed, but then also two, identifying if there are any additional evidentiary needs that we would have to actually successfully prosecute.
But as you're going through the process, and again, bear with me as I'm learning, 38 rules, we're out. Your team is encapsulated. They're doing their investigations and trying to get to a point where there is a recommendation that is then brought forth. So, okay, got it. Thank you.
So once the investigation has actually concluded, there will be a referral over to my team, similar to police and the district attorney's office working, just as a kind of comparison there. My team will then take a look at the investigatory file, perform our own due diligence review, identify if there at times there is a need for further development of a matter. And so we will work with the investigations, testing team, et cetera, to fully or kind of follow up on some of those items. We will then work in coordination with the CIE to present a recommendation or present options for how we may enforce. And then there is a conversation, further conversation with the executive director before any action is taken. And so I know we discussed this a little bit last week, but there are a number of different tools that we have available at our disposal. We can issue a summary suspension order. We can issue a notice of fines. We can issue an order to seek revocation or suspension of a license. So that will be part of that conversation with the chief, with the executive director in terms of what direction we want to take. As we are moving forward, once a formal order has been issued, we do always offer there is an opportunity for licensees to request a hearing in the majority of those circumstances. And then we also will offer informal dispute resolution. So that is really just a negotiation to see if there is an opportunity for the parties to connect and move forward with a proposed stipulated agreement, which is where we are today. So through stipulated agreements, I just want to note quickly that oftentimes there will be an agreed upon monetary penalty. That penalty pursuant to statute 94G section 14 will be deposited in the marijuana regulation fund. That regulation fund, 15% of that annually is transferred over to the social equity trust fund. Additionally, that money is used for a number of different public resources too. We may also see donations to the Social Equity Trust Fund through these orders or through these agreements, which may help to offset whatever the agreed upon monetary penalty is. But that would be one option that we will see in one of the agreements today. Additionally, we are always looking to ensure future compliance through agreed upon affirmative relief. That may include trainings, that may include kind of a probationary period or automatic assessments if we identify similar violations moving forward. And then we also are looking to make sure that we are ensuring personal accountability if we identify any folks were particularly implicated with directing the violative actions. So all of those are different areas where we're looking to kind of make sure we're incorporating them into these agreements, because we are, at the end of the day, trying to ensure that the licensee is able to move forward in a compliant manner and the agency is able to work with them to ensure that compliance. So with that, I will, we can transfer over and talk through the two different items that we have for you today, or for your consideration today. The first one that we will place before the board for consideration is a stipulated agreement with respect to DMA Holdings LLC. And so this licensee, or this company, has a number of licenses. So they have Greatest Hits, which is a retail location in Dudley. That license number is MR283264. Two retail locations under the name Tree Market. There is one MR282587 and MR282. Oh, excuse me, I'm seeing the same number for both of those ones, but they have two retail locations under the name of Tree Market. They also have provisional licenses for a cultivator and product manufacturer. And then, so I will pass this over to Associate Enforcement Counsel David Tennyson to speak through or give a brief presentation of the agreement.
Thank you very much, Enforcement Counsel Goodham. Good afternoon, Mr. Chairman and Commissioners. My name is David Tennyson. I'm an Associate Enforcement Counsel here at the Commission. For your consideration today and vote is a stipulated agreement to resolve an ordered show cause issued against the multi-adult use retailer licensee DMA Holdings in October of 2025. For context, DMA Holdings was placed into a receivership by the Massachusetts Superior Court in January of 2025, and as a result, Mr. Thomas Pratt of Applied Business Strategy was appointed to serve as the receiver and manage DMA's operations and finances pending a resolution to that action. And as such, the agreement before you today has been negotiated with Mr. Pratt and his counsel through his appointment as the receiver. To summarize the Commission's findings, this matter was first investigated in the spring of 2023 when the Commission learned that DMA Holdings had been funding and illegitimately cultivating marijuana at a private residence leased by two principal owners of the business, which was then distributed to the business's agents through an employee benefit program titled Free Joint Fridays. Through its investigators, the Commission determined that the licensee had cultivated marijuana at a location unapproved by the Commission and without a final license to do so. And during the alleged time period, the licensee exhibited conduct that collectively displayed a lack of responsible operation. Through the proposed agreement, the parties have jointly agreed to resolve this matter through the payment of a monetary penalty, the surrendering of certain agent registrations and licenses, and other negotiated affirmative relief. Enforcement feels strongly that these terms sufficiently address and resolve the violations alleged and sufficiently deter future noncompliance. The licensee has agreed to pay a monetary penalty of $100,000, which is to be paid over the course of 4 months. In addition to the monetary penalty, the licensee, through the receiver, has agreed to surrender all agent registrations associated with the two principal owners who are heavily linked to this action. The receiver attests that neither of those principal owners are actively involved in the licensee's operations and that DMA's marijuana and that as DMA's marijuana licenses are sold and ownership is transferred, that neither of the principal owners will retain any ownership status, which would classify them as a person having direct or indirect control, as defined in our regulations, and that neither owner will receive any sum, share, or distribution of equity as a result of those sales. The licensee has also agreed to surrender its provisional cultivation license within 14 days of the ratification of the agreement. And lastly, the licensee has agreed to develop and administer a training for all its agents to directly address the noncompliance alleged in the commission's order to show cause, providing tools and resources for its agents as well to report noncompliance concerns to both the business itself and the CCC. Before concluding, I would like to recognize the incredible work and efforts done on this case by Investigations Manager Timothy Barwise, Associate Enforcement Counsel Tisa Chikwueze, Associate Enforcement Counsel Jerome Hanley, and Enforcement Paralegals Barbara Cooney and Amanda Dupuy. Enforcement recommends that the Commission accept and ratify this agreement as an appropriate resolution of the violations contained therein. We feel strongly that the negotiated terms appropriately address and resolve the violations displayed by DMA and its principal owners, and we are confident that it will also deter future noncompliance. The agreement reinforces the agency's commitment to ensuring that the Commonwealth's regulated marijuana market remains safe and is held accountable. I am available to answer any questions.
Thank you very much, David. Appreciate it. Commissioners, questions? And I'm looking at Commissioner Delabato. She hit her mic first.
It's like one of those games where like whoever hits first. Okay, mine's specifically regarding to the fine. So I'm just curious to know how this fine compares to other similar situations.
Thank you for your question. What I will say is that the amount before you today is not necessarily a fine, but more of a monetary penalty that was negotiated by the parties to address the concerns. And we feel that it is an adequate resolution, especially combined with the other negotiated affirmative relief.
Commissioner, if I may also add to this is the violations that we see here are a bit unique with respect to historic violations that we've identified too and taken an action on. So performing that comparison is a little difficult here as well.
So just so as a follow-up, when we came to this conclusion, then like, I guess I'm just curious if you can walk us through how in this agreement, as much that can be shared, you came to this number, right? If there's nothing to compare it to, just thinking about, and there's clearly a lot of,
Can I jump in on that one?
yes.
Because I've done a little research and asked some questions, and I might have an answer for you. Given the nature that this is in receivership, we are capped at the amount. Is that correct? That we are allowed to assess in the form of this settlement, and I think it's capped at 100,000.
Mr. Chair, but I just a slight tweak on what you're noting there. This is the amount that the receiver can pay without going to the court for additional approval.
The receiver is limited in what they can offer.
In terms of their authority without further court approval.
Got it. Yeah, that was my understanding as well. Thank you. But feel free to further.
Commissioner, to your question, so what I will also note here is that we did find 2 violations. How we would look at those necessarily if we were performing just a general assessment. These could be viewed reasonably as category 1 violations, which therefore would allow us to go up to that max. So looking at 2 violations, which we have agreed to in this stipulated agreement that's before the board for consideration, we do believe that this penalty is in line with the potential assessment as well.
Commissioner, any questions? Commissioner Wilson?
Yes, I have a couple. I'll start with the procedural questions, and I think actually it was just answered. So if this were to be rejected and they were to go to a hearing and lose, the largest penalty they would pay is $100,000.
Commissioner, and I would definitely defer to general counsel too in terms of any kind of the specific procedural items in terms of if it is rejected here, what process would move forward following that. However, what I will note is that the initial assessment does differ from this agreed to penalty right now. So if we were to move forward with the hearing process, it wouldn't necessarily be the exact agreement that we are seeing or that is being considered by the board right now.
Well, I mean, I think I can ask this. I mean, we've got two violations in this packet, of course. One of them contains, I think, a number of different pieces. So I guess I was operating on the assumption that each of those pieces could itself be penalized. But I just want to make sure, like, if we went to a hearing, if we were to assess the penalties, we the commission, right, regardless of the process, and it would be upheld or held, it would be over 100. It could be over $100,000. Is that correct?
Yes, Commissioner, it could be. And what I will note is that in this instance too, there was consideration of the length of time and the number of days that the violation did occur or took place over. So that would go to what I noted in the,
50,000 each day, in addition to 50,000 each violation.
not saying exactly what that is, but yes, that is where our regulations kind of cap it. It's for per day or per violation.
Okay. So this is sort of on the lower end of the potential. But I mean, it's an agreement, so they're getting something. Yeah, okay. Then just procedurally, DMA Holdings was not the violator, it was the license holder at the time, which was Tree Market.
Thank you for your question, Commissioner. So at the time, the DMA Holdings is the parent company that possesses the IP of Greatest Hits, its flagship store in Dudley, Massachusetts, and they also are the owners of the Tree Market licensees, which are in addition to that store.
Okay, so yeah, I just want to make sure I understood. So DMA is not the receiver. The receiver is taking over DMA.
Correct.
All right, and there's something later on in our agenda about that. Okay, so I just want to make sure. So we have the right party in front of us, DMA Holdings, the licensee that violate the provisions that are of their license. Okay. So then a few just sort of interesting things that I sort of saw here. So part of this complaint is around cultivation in a non-licensed facility. I guess the complication for me in Massachusetts, people are allowed to grow a certain amount of cannabis in their homes or whatever. When I read the complaint, these were individual homes owned by by these two individuals who will no longer be allowed to hold licenses or badges. I'm just curious, how are we sort of, this is more philosophical, how are we understanding the interplay between those two things?
Thank you for your question, Commissioner. Though the private residence where the cultivation occurred was leased by those owners, the fulfillment of rent, the upkeep of property, and the cost of cultivation supplies was all bared on part of the of DMA Holdings itself. And so this combined with the fact that the marijuana was unregulated and being distributed to employees caused us to view it as crossing over that private operation to a licensed activity.
Let me just put a hypothetical to you. I can, if, I've got a lot of practice. If I grow cannabis in my, well, I guess you're saying it would be a violation of the law. If I grew cannabis in my home for my own consumption, then I distribute it to people if they work for me, I would be in violation. Not of a license, but of.
Is this a hypothetical, Commissioner? Or just for clarity?
I'm just thinking through.
Commissioner, if I could,
This is a hypothetical. I will also hypothetically.
I will speak to kind of the commission's findings that are contained within the four corners of this agreement here. In essence, our finding is that their practices and conduct amounted to the operation of a marijuana cultivator license, which they did have a provisional license for. So they were utilizing their business funds to pay for the location, pay for the materials, pay to cultivate the marijuana here. They were also utilizing volunteer employees to assist with the cultivation. They were also using that marijuana they were cultivating at that residence to, in essence, further their business, or they would utilize that. Incentivize employees, exactly.
That makes.
So that's the
the
connection.
heart of it was, all of that stuff makes sense. I was wondering if part of the nexus could be the amount, because you're allowed to grow a certain amount, and I didn't know. It's not here, and I guess if it's not here, I'm not gonna press it. But if you're over a certain amount, then that could also factor in. That was kind of something I was thinking about. But again, it's not here. So last couple of things, which is, I was very interested about the message to the employee about the Instagram post. I guess it seems unnecessary to me. I don't know if we care about posts. It wasn't, when I read the message, it wasn't about hiding information from the commission. I'm curious how that factors into a violation.
Sure. So as for the second violation that is contained in the commission's findings in the stipulated agreement, we're really looking at a collective display of conduct that we felt as though demonstrated a pattern of irresponsible operation of a marijuana establishment. So that fact alone is just one aspect of the entire violation itself. It is combined with a number of other factors.
Okay, I take your point. I guess I could see a person running a business getting amped up about something being done. None of it's, if I were to take that message, nothing in it seemed to indicate anything about things that we would care about as a regulator, make sure cannabis stays within the legal market. But I take your point. Last question, I guess, could you walk me through a little bit about the receiver process? Did they go through the process because of something we initiated? Was it initiated on their own? I should know a little bit about how they initiated the receiver process, how the receiver was chosen. I'm assuming there's no relationship between us about how all that sort of went down.
That is correct. The receivership process was started privately through, my understanding is through creditors of DMA Holdings. We did not necessarily have a play in that process.
But I'm assuming they may have started because they knew this was going on. But yeah, but you don't know, again, yeah, that's fine. Yeah, I'm cool. I guess we'll have a vote. So I'm fine. The only thing is, I guess there's these two individuals could come back at some other facility and get badges. There's nothing in this agreement prohibiting that. They're just losing their badges at this facility. And it seems like if they were so bad, basically, I guess I'm wondering if there's provisions for us to have a long-term suspension for them specifically. I didn't see that in the agreement.
So, Commissioner Wilson, what I would note too is that under our suitability tables, I do believe that this would implicate suitability for those owners. I will note that in all of our stipulated agreements, just as part of the general boilerplate language, we do include provisions that note the commission may take those into consideration. Generally speaking, we have not moved or executed based on those provisions. However, in certain circumstances, depending on the facts that are presented, we do have other options where we would be able to look to that. So here there is there's a surrendering of those agent registrations. And you're correct, there was not a ongoing suspension of those individuals because we are just getting the surrender of those registrations. But if there was a intent for them to apply for agent registration, ownership, et cetera, in the future, that is something that could be considered by the board in terms of granting a license. It also could be considered through the suitability process, potentially.
I have no more questions, Chair. I'm in favor of moving forward.
And my takeaway there is we would have another opportunity. If they came in front of the commission again for another license, that is something we'd have the opportunity to review. So, which is good. So one observation and then one question. I had also read 47 payments, $63,000 that went through that facility using business money. That in my mind kind of tripped it. They pierced the veil when they did that. So on that particular piece. One question, and we had talked about this a little bit earlier, like how do these things get started? I'm always curious. So where did this one, what was the genesis? Was it an internal? Was it an external? Are we allowed to say? Okay.
Yeah, this one came through in external referral.
Got it. And when did that referral come?
In spring of 2023.
Okay. Just out of curiosity too, so 2023 and we're now spring of 2026, 3 years. Is that normal? Is that kind of what we have historically seen? It takes that long to get through a process of investigating and then going through the process to develop the stipulated agreement and negotiations?
Yeah, Mr. Chair, happy to answer that. So I don't have the numbers specifically in front of me, but I will say just in general that there are a number of different factors that will go into any investigation, into any enforcement, and into the subsequent enforcement action, which may affect the overall timing of that particular matter. I would say just as a broad matter for any sort of kind of investigation that is even moderately to even more complex, those could take potentially up to or over a year to fully dig into. And with respect to kind of the enforcement council process where we are performing our due diligence, that also may take up to around a year. And that is incorporating kind of any internal or external collaboration. So if there is the need to develop the evidentiary record a bit more, that will take some time trying to get in touch with folks for interviews, et cetera. The hearings process also, what we are doing now in an interest in trying to make our process more efficient. Previously, and that did not occur here, but in prior instances, what we used to do is we would offer IDR first. And then depending on the outcome of that IDR, we would then proceed to the hearing process. What we are doing now is we are proceeding on parallel tracks. So that is hopefully going to speed things up a little bit. So we will perform that. We'll offer IDR and a hearing at the same time. We will then try to engage in IDR typically first, and then we will see where we will go with that. But that negotiation at times can take a little bit to actually try to hammer out the specific details, but that could take a couple of months as well. So I would say that this is not an abnormal time.
And when did they enter receivership? So this all began in 23, but was that shortly thereafter, or was it recently they entered receivership?
They entered into receivership, Mr. Chairman, in January of 2025.
Got it. Thank you. It's a fascinating, again, for another day, but for the other commissioners, you know, the process when a business is struggling, the ability not to go through kind of a normal set of bankruptcy proceedings and have to go through a receiver process. That's another interesting topic. And I'm certainly not the expert on bankruptcy versus receivership, but I've dealt with both. Not personally, not hypothetically, but that's a very fascinating challenge in this industry that at some point we should probably discuss further. Okay, I have no further questions unless there are from the commissioners. So yes, go right ahead, Commissioner.
I also, and this actually goes through both of the stipulated agreements, I was, you know, whatever you guys can do to make these go a little faster. And again, I know you're working hard, but I do think not knowing anything, I'm hoping there's a way to speed some of this stuff up because we're not even in a hearing phase for 3 years. It just brings an agreement for us.
Good point. And again, thank you all for bearing with us as we continue to educate ourselves and going through these processes to understand them. A lot of moving parts, but very important work. So we appreciate you. And I'm going to turn to GC at this point. Is it appropriate that we make a motion on this one, or should we go through the second and then do a group?
Mr. Chair, I would recommend that you do them one at a time. So I would do a motion on this one, and the motion here can be just as simple as motion to approve the stipulated agreement on DMA Holdings.
Thank you. All right. Do we have a motion to approve the stipulated agreement on DMA Holdings?
So moved.
And we have a second?
Second.
All right, roll call. Commissioner Delabato.
Yes.
And Commissioner Wilson?
Yes.
And Chair Harding, yes. So moved. On to our second enforcement action.
Thank you, Mr. Chair. And just to briefly introduce this matter, so the stipulated agreement before the board for consideration today is with respect to Legal Greens LLC. There are this licensee has 2 final licenses and 1 application pending. Just for the record, they have a retail license MR 282937, a cultivation license MC 282508, and then their application is MRN 285427. And I will hand this off to First Assistant Enforcement Counsel Nielsen to discuss the details.
Thank you, EC Gooden. Good afternoon, Mr. Chair and Commissioners. For your consideration and vote is a proposed agreement that would resolve the order issued to Legal Greens if ratified. The agreement reflects the parties' agreed to facts of record, applicable law, commission findings, and stipulated resolution. The Commission's investigation into the violations outlined in the agreement started in February of 2023 and concluded in November of 2024. The Commission issued its order in December of 2025, and the parties engaged in dispute resolution and the 30A process throughout 2026, resulting in the agreement before you today. Through its investigation, the Commission found that Legal Greens had failed to maintain a workplace free from drugs and alcohol, permitted an underage family member to affix labels on empty marijuana packaging and branded goods, and allowed personal cultivation of marijuana by one of the owners. All of these violations occurred in the basement of its establishment, which was not identified as part of its licensed premises in its application. Throughout the investigation, Legal Greens fully cooperated with the Commission, has resolved the violations, and agreed to take further action to ensure future compliance. Through the proposed agreement, Legal Greens and the Commission's enforcement staff jointly proposed to resolve this matter through the payment of a monetary penalty, short-term suspension of one of the owners, and other affirmative relief. Those negotiated terms are as follows: a $52,800 fine to be paid in installments over 12 months, a $3,600 donation to the Social Equity Trust Fund by each of the two owners involved in the violations for a total donation of $7,200. A 1-month suspension of the owner who grew personal marijuana plants at the licensed premises. A requirement that Legal Greens formally include the basement as part of its licensed premises. A requirement that Legal Greens hire or promote a person to the position of compliance officer, and the development of a training that educates Legal Greens employees on the violations identified in the order. For concluding, I'd like to recognize the effort put into this investigation by Investigations Manager Timothy Barwise, Roy Mushingera, Ryan Basting, Investigator Timothy Parsons, and any other staff who assisted in the matter. As for my team, a big thanks to Associate Enforcement Counsel Tisa Chukwueze, as well as Enforcement Paralegal Amanda Dupuis and Barbara Cooney. Enforcement recommends that the Commission ratify this agreement as it represents what we believe to be an appropriate resolution of the violations. We believe that the fine serves as sufficient deterrence of the conduct and is consistent with the assessment where there are two violations that create a potential threat to the public health, safety, welfare, those being those Category 2 violations. And a third that creates a climate conducive to abuse and non-compliant operation, that Category 3 violation. The proposed donations and suspension of one of the owners add a layer of personal accountability of those owners for their involvement in the violations. And lastly, the agreement reflects a renewed understanding by Legal Greens of the regulatory requirements and acceptable operations, focusing on its efforts that it will take towards assuring future compliant operations through training and the creation of a compliance officer. I'm happy to address any questions that you might have about this agreement.
Thank you very much. Commissioners, questions? Commissioner Wilson.
Kind of building off of the last agreement. This is one that actually sort of concerned me a little bit more because they're growing, a individual is growing cannabis in the building, presumably for personal use. But this seems like more of a situation where it could then get the stream of the stuff that they have otherwise, right? It could have gotten mixed in with what's the regulated environment that can be sold. So I guess I was a little bit surprised that they've got the same financial penalty as the 51% owner who did not engage in that specific content. Not to say they shouldn't have overseen. So I guess I'm a little, I guess, walking me through why they are not having more of a penalty than the other person.
Sure. Well, what I would say is that both of them are statutory violation. One of the owners that was involved, their family member was on premises, was an individual who was underage. And to add a little bit of context, with taking into consideration the fact that there was the consumption of, or evidence of consumption of marijuana and alcohol in the basement, having the underage individual around that provide some aggravating circumstance that would elevate that sort of statutory violation that was there. As it relates to the individual who's doing personal cultivation, we had no evidence demonstrating that there was any entering of the stream to the business itself or outside, or not any evidence that we were able to corroborate. So for those reasons, that's kind of where we landed on this. I'd also say that this was an agreed to assessment here. So this was what was proposed by those individuals in what would be personal accountability. And I'd also like to note that at least for the individual who was engaged in that personal cultivation, in addition to the $3,600 donation that you'd be providing to the Social Equity Trust Fund, he is also receiving a 1-month suspension on top of that.
I have another question, but just to follow. If it were to go to a hearing and sort of a penalty were to come from the commission, based on these facts, my understanding that individual could get a different penalty than the other one.
It's possible that that could occur.
So I guess in circumstances like this, I mean, you're right, they do have the suspension. But and we can't dictate people to make donations, but they've agreed to that here.
Correct.
I guess I'd like to see a little bit more onus on a person who's growing product in a facility where this risk is increased, whether you have evidence for it or not, they would agree to it. I think that they should take accountability for that. And then I'm also curious, just walk me through on the ground, because, I also wonder if the suspension is enough. What is the impact of having my registration badge suspended for 1 month? You're still an equity holder of the business. They're not going to stop I don't know if they receive a salary, maybe that'll be effect, but I doubt it. I don't think there's anything there that affects that. So what is the effect of a 1 month badge suspension?
So if you look at page 8 of the stipulated agreement, it contains what the conditions are of that suspension, and that would be that individual cannot be present at any of the licensed premises. That would include the cultivation and then future potential application that they have for the other marijuana retailer. They are not permitted to work or volunteer at any of the establishments, and they can't conduct any activity that would otherwise require an agent registration. So they are out. To the extent that there is anything else, that would be beyond what the stipulated agreement has stated. So
Yeah, I think you're getting the gist from that. I think it's a little bit too light. The only thing that I would say, I'm not going to vote in favor of the agreement, only because I also think that they say if we got pending applications, I would think that like the previous one, they should surrender or cancel those pending applications for other things for some period of time, because they cannot operate, or they haven't operated their current facility within a manner that we deem suitable. I know it's been, what, a year or so and it said that there's been no violations, but again, that's also one of my concerns about the speed of the investigations. But so I guess I want to hear from my colleagues, but I guess that's kind of where I'm leaning at the moment.
Commissioner Delabato.
All right, so a couple things. For me, first, which you answered this, but I'm also curious about just how we arrived to this fine. And I know it's not the best practice to compare any, situation to the other, right? I just, and I think I'm on a different side than Commissioner Wilson right now, where my initial reaction to this is that the fine is really high, in my opinion. And considering the types of violations that are here in comparison to other violations that others have committed, which are more aggravated, from my opinion. And I don't, and for me, that's a little, it just jumped out at me, and just how high that was. Also, and I'm just kind of free thinking right now, when it comes to different floors, right? When we license and we have different floors, aren't we, and maybe this is a question for ED and GC also, when we, let's say we have a building of 5 floors, aren't we able to license just like floor number 5, right? And then anything can happen in floor 1, 2, 3, 4. So in this situation, it kind of, that also jumped out at me. Like if the downstairs, if the basement, if we're licensing the main floor, and then the basement, from what I understand, there wasn't, correct me if I'm wrong, I'm not sure if there were specific products or just the labeling of products down in the basement again. If you can just point me to that specific area, that would be great. So it just seems like there's a lot of, there was just a lot of assumptions, at least the way I'm seeing this, for that, like with the activity down in the basement. And also, and mainly because understanding that there's, the difference of being able to license or register, various multiple floors, and if we don't have product in those spaces, then, and if you have, in this, you have someone who's just labeling, that's different than like I'm handling a pre-roll, right? And also just like the alcohol, I agree, right, with the mix of, alcohol and all that, but that's also the question that came to mind to me when reviewing this. We are also assuming the way it was written, we're assuming that consumption happens then, but that consumption could have happened, I don't know, a week prior of alcohol, right? Like we all, I'm sure anyone who drinks alcohol, we have empty bottles or like half-filled bottles in our homes and all that. You know what I'm saying? So we're like assuming that that consumption was happening in that moment. And because there's too much doubt presented to me in some of those pieces, it made me pause on moving in a direction of, reinforcing this, but also like, I do think the fine is really high for these for these specific infractions. That's just my opinion. That's just my initial reaction to this.
Really interesting. And this is good. We're having good constructive dialogue. It's fascinating because if I'm hearing correctly, Commissioner Wilson is saying it's maybe not enough, and I'm hearing Commissioner Dilibato saying it's a little bit too much. I'm probably down the middle on this one, but before we debate further, question, because both commissioners have brought up the fairness of the fine. One thinking maybe it's too low, penalties. One thinking maybe it's too high. Can you give us a little bit more context to this one in the context of others that we've done in the past? Because one of the things we strive for, I believe, is consistency, and that we can justify, okay, we're doing this set of enforcement actions based on 5 other cases, or does this fall out of the norm? So I think that would be helpful if you could describe that a bit further.
I worry about giving you an answer that's not satisfactory because like the previous case, this is a unique circumstance that the commission is presented with. Perhaps the cultivation at the premises without a license is something that's slightly different from the other matter that you just voted on. But with respect to having an underage individual at the premises, again, that's not something that we have taken up as an enforcement team as of yet. SOP violations are, I would say, something that is standard. And like I said, for this specific circumstance, we would have identified that as being that category 3. And that's, I can never remember this one, but let me read the specific language that it creates that climate conducive to abuse and non-compliant operation. So here in this case, we felt that we fell squarely within where we would be at if we were looking at the assessment that we could have for a penalty for those few violations, and then also considering the fact that we have come to an agreement with the other party on what they are comfortable with paying with, and what we feel also serves as a deterrent effect in case that there are ever future violations or for other licensees if they're engaging in this practice. Mr. Chair, if I may address some of Commissioner Delibato's comments. With respect to licensing different rooms or different levels of a building, you are correct, but what I would say kind of in response to that is that it depends on how you are using the other spaces. And here in this case, how this licensee was using its basement indicated to us that it should have been included as part of the licensed premises. They're using it as an employee break room. They're using it as offices for the 2 owners for marketing purposes, and they really treated it as part of that location. And if you look to the definition of premises in our regulation, it says it means it's any indoor or outdoor location over which a marijuana establishment or ITL or its agents may lawfully exert substantial supervision or control over the entry or access to the property and the conduct of the persons. Here, this licensee specifically allowed its agents to use this aspect of the building that it was occupying for certain purposes that serve the purposes of that licensee. So for those reasons, we are confident that this should have been part of the licensed premises. The licensee now understands that. Now, does it mean that they have to have camera coverage of the basement? No, if there is not marijuana products in the basement, they would not need to have camera coverage in there. However, they do need to include it as part of that licensed premises if they are indeed using it for an employee break room, for administrative purposes, whatever it may be. We need to know what is occurring in there. And when we went and investigated this matter and discovered these things, it was concerning to us.
Quick follow. Can I have a quick follow-up to that?
Yes.
So it's
By all
great that just to hear that the licensee understands that, and I completely hear what you're saying. Couple thoughts. One, the other thing that jumped out at me and just kind of this reaffirms what you just said, where they understand now, right, that this level, it's serving the business, right? So the activity, we need to know, right, about that, which I completely understand for any of the businesses out there. I did notice in this that they did put in a plan, of correction, right? So, and that plan of correction, they submitted it, it was approved in August of 23, and that there hasn't been a reoccurrence. So basically 3 years later, this licensee is doing their thing, all within regulation. And so it goes back to, one point, previous conversation, the length of time is really concerning, right? Because like this happens, we've already rectified this literally 3 years ago. And it's now, and I understand the process, right? Like there's process and people reviewing and all that. So I just want to make it very clear. And I also agree with Commissioner Wilson on, like, we need to look at that, but that's, offline, working with the team and all that. It does, though, lead me to definitely double down on my opinion, where I do think the fine is just too high, considering we have a 3-year lapse of good standing, where there's this understanding of how to, making sure that we're not using various parts of the premises in a way that's not registered, where we're not aware of, and continuing good business. There's that piece. And then I find, the one, just for perspective, I think it's important for us to look at all sides of the situation, because I don't know if any one of us has ever been part of family business before. I have, where at 15, helping aunts and uncles and my own parents, in shops. And I think that is a very realistic situation. So, based on strictly what we have here, where we have a family member who's helping labeling, I think like that's a very real support, especially when we're looking at small businesses. Not like, because we're also asking them in this agreement to bring on new staff, right? So like, I mean, that's a cost already. That's an expense that we're adding on top, or, it says like hire or promote, or like name someone, in the business. So I'm just kind of thinking out loud on that, where there is, and I understand, having the 18, anyone under 21 on the premise at a business, I get that. I'm also looking at this, it feels very gray to me, where because that floor wasn't registered, and I'm curious about conversations prior to that, like the level of awareness, education, like that was there beforehand, to really ensure that our licensees understand those parameters, and that they will be enforced, right? So that piece, and also just like bringing into context. And I don't know these business owners, I don't know the family, but just from my own personal experience, like the level of family support is really critical in many small businesses. And and I see that that's what I see in this current situation, right? We have family helping a small business.
Go right ahead.
Apologies. I just want to clarify something. I am not necessarily in favor of raising the fine. I'm more in favor of shifting more of the fine to Mr. Bouquet, who's growing product in this unlicensed area. And it's my understanding that we can, in addition to fining the business that is the licensee find individuals. So, that is what I'm saying. If we reduce the 52,800, that's fine. I just think more of the burden should be on that individual based on the conduct here in the stipulated agreement. So I'm not in the fine increase. I'm in the reallocation. Yeah.
You want to respond to that? I have a couple questions too, but I can wait.
Yeah, just want to respond to one of the items that Commissioner De Lovato was bringing up as well. And I can definitely appreciate what you're identifying here. I mean, when I was 15, 16, worked at my cousin's diner as a dishwasher. So like working with a family business too, I absolutely hear where you're coming from on that. The context, and you kind of spoke to this a little bit, is that I just wanted to add here is that the statute specifically prohibits anyone from any marijuana establishment from employing or allowing volunteers or any minors on premises. So here we're talking about kind of a higher authority, even in the commission regulations, where that is specifically prohibited in statute, which that what First Assistant Enforcement Counsel Nielsen spoke to as well, that kind of weighed into our initial assessment of this violation too, because it is a statutory violation. It is even a heightened violation over our regulatory one. So just wanted to add that context, but definitely wanted to note that I hear what you're saying in terms of the kind of education components, et cetera, that goes into that. With respect to that, what I would note is we have the facts as outlined and agreed to or stipulated in this agreement. So we don't want to go beyond that for to avoid risking any kind of 30A implications if this were to need to proceed to a hearing. But those are definitely factors that were considered as we were moving through this process.
Okay, a couple of questions. This organization, any priors?
If by priors mean any other enforcement action.
Yes,
No, there are no other enforcement actions taken against this license.
And and am I to believe if I go to page 640, respondent has cooperated through all investigatory stages of this matter and has corrected the violations alleged in this agreement, has agreed to take further action as detailed below. Sounds like they were very cooperative and changed the things that were at issue. Is that correct?
Correct.
Which is probably not always the case, I would imagine. But I think that's worth noting. The other thing is, do we have any sense at a time when we have a lot of change going on with the businesses, do we have any sense the kind of burden that this puts on that business? Is this a tipping point that we'll be talking about this one in a receivership in 6 months and talking about change of ownership because of the $52,000 fine?
Okay, so what the burden you're speaking to is
Yes.
I do not have a sense of what that would impact on the business. What I would say is that this is what they agreed to resolve this matter. So I imagine they do their own due diligence.
It's a fair answer. Okay. So let me see if I heard everything correctly. There were violations. We're all in agreement on that. And against statute, they did cooperate fully. They corrected the deficiencies. There were no priors. It feels like we're down to a question of amount and also potentially a shift of the burden. So let me ask a question. Is that something that we could do? We could actually shift if the three of us agreed or two of the three agreed that it was appropriate from our seat?
Mr. Chair, I would defer that question to General Counsel.
And before you go, Calll, so when these come in front of us, my understanding, we can have a motion to approve and we move on. We could have a motion to reconsider with some guidance, I believe, and hand that back to enforcement. And then this can be brought back in front of us again. Or three, we just deny outright?
Yeah, I thank you, Mr. Chair. I guess I would change the options a little bit, and I would suggest to you that, so the decision here is to approve or reject.
Got it.
And if you're rejecting, the suggestion would be to just table this for now, but to give the enforcement team very specific instructions on where you fall as a group and what you would consider acceptable so that they can go back and restart the negotiations with the licensee. And if they can reach an agreement, then they'll bring it back. If they can't, then it would go through the hearing process.
Very, very helpful. So we're all being open. I'd love to hear others' thoughts, but where my head is at, I'm kind of leaning on the side of some level of leniency. Yes, they made some mistakes, but they were fully cooperative. They've corrected. I don't want to put undue burden on organizations that are trying to do the right thing. And it's also gone on over a long time. So I'm kind of leaning in that direction myself. Yes, there should be enforcement action. Yes, but maybe where there's a little bit of leniency there. That's kind of where my head is at, but others?
I am aligned with that, Mr. Chair.
I guess I would just sort of, so I think I could go in that direction. I think, as we consider allocating I would like to see a little bit more on sort of who is responsible for creating the worst part of the violation. That's not always the case, but I would like to see that in future agreements. And I'll leave it there. So I'm on board with you, Mr. Chair, and I just sort of send that message to the enforcement team.
So what I'm hearing correctly is that we are probably aligned on a motion to table for now with the feedback that we've just provided, and we'll let enforcement go away and continue their dialogue and come back in front of us. That's what I'm hearing. Do you agree?
Yes, and I want to make it clear that, at least for me, is that fine be reconsidered to a lower number.
And I agree with that as well. And again, the message that I think I want to send, and hopefully we're all in agreement, is A, if you step over a line, there are consequences, period. So there will be. But B, if you are trying to do the right thing and you're not trying to hide it or deny it or whatever, but you're immediately jump on board to correct, that's very, very strong statement, and we should be supportive of that. And at a time when businesses, some may be struggling, let's try to have a little bit of grace if we can within our authority. So I think that's kind of the message that my head is wrapping around a bit. And Commissioner Wilson?
No, I fully agree.
All right, so I think we're aligned on, do we have a motion to table?
So moved.
We have a second.
Second.
Roll call. Commissioner Dillabato
Yes.
and Commissioner Wilson.
Yes.
And Chair Harding, yes. Motion tabled for now with that feedback. And if you can bring this matter back in front of us. And again, I'll just underscore for those that are online and listening, hopefully that message is coming through. This commission has a responsibility, and we will always live up to that. But part of that responsibility is also to try to understand the context and be supportive of businesses that may be struggling. So they're trying to do the right thing. We'll try to do the right thing as well. So, terrific. I appreciate all the hard work. We know, please take this the right way. We think you did really good work here. And, just all the documentation and everything that's been provided helps to make it clear for us. So we appreciate you as a team.
Mr. Chairman, can I just pile on that?
Executive Director?
One moment. So I just want to highlight a couple of things too, because we talked about timelines and expectations on that a lot. I know Enforcement Council staff had taken a lot of time with General Counsel towards the end of our previous board on talking about some of those things. I know that Enforcement Council has given you all kind of an explanation of in his tenure in the role, the efficiencies that have been found. Some of the conversations we may have as we move forward, will there be regulatory changes or things that considered at the board level? They give us additional tools to make this more efficient. I just want to set the expectation as of right now with the tools that we have, the efficiencies that have been found through our Enforcement Council staff and working with others, we'll continue to obviously hone and continue to improve on. But ultimately, some of these items that are 3 years in and those types of things, the reality is that the investigative process to hand off to enforcement is always going to take a period of time. So at any given point, the majority of these things are not going to be happening and coming to you in real time. So I just want to obviously set that expectation as well. The goal obviously is to make these more efficient, get them through our staff for our staff's sake and the licensee's sake, and to you all as quickly as possible. I just want to set that expectation. And I think Commissioner Wilson had noted before, some of those conversations as we get into regs throughout the rest of the year, we'll have those discussions. The tools that we currently have, I just want to point out, and we've discussed significantly in the past, and you've got some presentations on the work that's been going on. Those are in process, but as well, you also just heard 2 cases that I think probably started before our current Enforcement Council, and so they're taking them to the finish line. And so just want to, as well as the chair just noted, give them kudos for that, as well as the rest of the staff.
Very fair comments. And, on behalf of the new commission. We understand and we appreciate that very much, and thank you. And without the benefit of experience or as much knowledge as many of you have in this room right now, I think we'll continue to push on this front, like even on the speedy part. I mean, I grew up with right to a speedy trial. It's like, it's not, have this drag out forever. So I think as we go forward, where we can find efficiencies, where we can move with haste, I think it just benefits everyone, the businesses, the commission, the consumers, the patients, everyone, all the stakeholders out there. So hear you 100%. And again, without the benefit of the experience of all the wonderful work you're doing, we'll continue to push. That's part of our job. So, but appreciate it.
And appreciate that feedback, Mr. Chair, as well. I mean, learning the three of you and your kind of perspective is definitely going to help us as we learn and adapt, and we'll definitely make sure that we're taking that into account as we move forward. So appreciate that feedback.
If I can compliment my fellow commissioners here, I think part of what's happening, and I've heard in our third meeting here, is you're seeing who we are, and we're all showing up with who we are and our point of view. No one is pulling back, and we're having good dialogue. So hopefully you'll learn us as well and the things that are important to us individually and then as a team. Great, thank you. So with that, wait, did we do our motion? We did? Yes, okay. Geez, you gotta keep me honest here. So we're moving on. I believe our next section, Executive Director, is staff recommendations on change of ownership. But before we do that, anyone need a break? Oh, there we go. So it is 2:15. How about we do, how much time? How about 2:25? We will be back online. Thank you all.
Yeah.
All right, took a couple extra minutes. Appreciate everyone. We are going to jump in now and we are going to, staff is going to talk to us about 2 change of ownership license recommendations. So Jamie.
Good afternoon, Commissioners. Thank you for having me once again. There are 2 change of ownership applications for consideration today. Additional information is contained within the executive summaries for the Commission's review and consideration. Commission staff have reviewed the applications for compliance with applicable laws and regulations and are presenting them for the Commission's review and vote. The first licensee is Tree Market Lynn LLC. They're seeking a change of ownership and control over 1 adult use license and are requesting to add 1 individual and 1 entity.
Okay, and for those that have not been keeping track, we had just discussed these organizations in our prior enforcement actions. And as I look at the ED, I believe we had moved the enforcement actions up so that we could address this at this stage, correct? Yes, okay. So commissioners, any questions on this transaction?
I have a couple of hopefully procedural questions. So looking at paragraph 6, 7, and 10, I guess I'm just curious. I'm not going to try to pronounce the name because I will look foolish. They're getting 100% equity and control, and then Green is getting 100% equity control. Then it's 90.1%. I'm just curious how those things relate. Like, what is the ownership control percentage? Why is it not 100%? Like, how those things relate? Sorry. So if I look at paragraph 6 and 7, this individual has 100%, is getting 100% control. 7, Green Emerald is getting 100% control. Then I have the individual's name in paragraph 10, 90.1% ownership and control percentage. I'm just curious how it goes from 100 to 90.1%. Or is the 100% control of something that I'm not seeing? I'm just curious how those numbers sort of track.
So that's what the applicants basically lets us know. So it's whatever they perceive their control to be. Control is a little finicky subject because it is difficult for people to often represent exactly what percentage of control. So I think that's their best guess of explaining what their control is going to be.
Well, because it also has 90.1% ownership. I'm assuming that's of the license.
Commissioner Delabata believes you might be looking at the wrong.
Yeah, so Commissioner Wilson, I think you're looking at Tree Market Taunton and we're on Tree Market Lynn, correct?
Oh,
Yeah.
Yeah, so
It was like, I don't
we'll
see
just
the
scroll a
90.
little further.
Good catch.
thank you very much, Commissioner. So again, sorry to be a pain. Similar kind of question. So we're going from 100% equity acquired to 44% ownership. I'm just curious about like how that's happening. Is this 100% ownership of a company and then that company only has 44% of the license? I'm just curious how those numbers are sort of transmitting through.
So I'm sorry, you're asking for number 6 and 7. So they are proposed to John Ferreira and the people listed are proposed to acquire 100% equity. And so the question is for paragraph 10.
Correct. Oh, I'm sorry. You know what? That's actually,
That's another.
that's another license.
Okay.
44% another license. I was reading this very quickly. So I have no further questions.
Oh, great.
Thank you. Thank you very much.
It's all about clarity. So if you have a question, ask it. There's no bad question. So I'm glad you did. And thank you for the clarification, Commissioner Delabata. Okay. Any further questions on this? Yes, no? Okay. Do I have a motion to approve?
So moved?
A second?
Second.
Roll call, Commissioner Delabata
Yes.
and Commissioner Wilson
Yes.
and Chair Harding. Yes, so moved. Okay, we are going to move on to commission discussion and votes, and this is followed. Sorry?
You got the second one.
Oh, I'm sorry. Yes, I thought we were doing them as a package. Okay, so Tree Market Taunton.
Yes, the last licensee is Tree Market Taunton LLC. They're seeking a change of ownership and control over 1 adult use license and are requesting to add 1 individual and 1 entity.
Commissioners.
No questions.
All right, do we have a motion?
So moved?
Second?
Second.
Roll call, Commissioner Delabata
Yes.
Commissioner Wilson?
Yes.
And Chair Harding, yes, so moved. Apologies for that. Forgot they were individual. Okay. So moving along, unless we have anything else, Executive Director? Okay. Commission discussion and votes. So again, I was starting to say this is follow on to the meeting that we had last week where we discussed promulgation of emergency regulations. So let me just read this. Introduction to Chapter 65 of the Acts of 2026 Regulatory Package. Today, we'll be discussing proposed draft emergency regulation amendments prepared by the legal team. At the last public meeting on June 11th, we voted to direct the legal team to draft an emergency regulation package that is responsive to Chapter 65 updates that the legislature and the administration have directed to be amended within 2 months of enactment of the new law. And again, we all know we were under the gun on this one because we weren't even appointed until 30 days in as a commission. And we appreciate the legal team on this. As we directed, the emergency regulations focus narrowly on the following updates. First, the 1 to 2 ounce change for adult use retail sales. Second, license caps and a social equity business exclusivity period. Third, license cap exceptions for ESOP trustees. Fourth, license cap exceptions for persons or entities possessing less than 20% equity interest who do not otherwise have direct or indirect control. And last but not least, equity holders possessing an equity interest of 10% or greater. If we vote to move this package forward today, it is not our last bite at the apple. And again, that's a phrase we used last week as well. We are doing this in order to be compliant with the directive from the legislature and the administration. Okay. It is not our last bite of the apple before these regulations become permanent. We will hold a public comment period and a public hearing to hear from stakeholders. And we will have an opportunity to make any changes before the regulations become final. As I also noted at our last public meeting, if the board moves forward with this emergency regulation package, we would begin addressing all other changes that need to be made to comply with Chapter 65 in the early fall in a large policy regulatory round. With staff working on these recommendations through the summer months and beyond, and with all regulatory changes made by April 19th, 2027. And that time is going to fly by, so we're on the clock. These amendments include updates to areas such as medical de-vertical integration, advertising, in addition to more holistic reviews of the medical program and testing regulations and protocols. With this in mind, we turn to the legal team to discuss these draft amendments. Over to legal.
Mr. Chair, if we can just take a very quick break, I'm going to turn the room down for mics, get them all set up over there, and we'll get
We'll
going.
take just a couple of minute break while we set up our tech. So we'll be right back.
Thanks.
All right, we are back. Thank you for your patience, and we are going to turn it over to the legal team for an overview.
Thank you, Mr. Chair. If we could just go back to the previous slide. Thank you. So the board has received, and in, I believe the public packets are the redlined version of the draft emergency regulations. We will just discuss them broad level, topic by topic. The first types of amendments that are shown through both 500 and 501 are technical type of amendments. First type of technical amendments are based upon the session law and statute 2026 chapter 65. So you'll see the new session law cited as well as the updated statutory references throughout both sets of regulations. Next up is the Cannabis Advisory Board. So chapter 65 repealed that body. So that body has been struck through both sets of regulations. And lastly, the last type of technical amendment is the update for medical marijuana establishment. So this is a new statutory term, and we've been adding that to the definitions section and replacing medical marijuana treatment center with that new statutory term. So you'll see that throughout. The next more substantive type of categories are the changes for the 1 to 2 ounces for adult use retail sales. So these changes come through in 500-140, where there's additional requirements for marijuana retailers, as well as sections relating to additional requirements for delivery licensees under 500-145 and 500-146. There's a very succinct change of the word 1 to 2 there, so very straightforward. The equivalencies for other product types will remain the same. The legislature did give the board the authority to review those equivalencies, so that may be something the board wishes to take up at a later date. Any questions as to the 1 to 2 ounce updates? Okay.
Not from me, commissioners.
I have none.
Great. Proceed.
Very good. The next section is license caps and social equity business exclusivity period. So there is a license cap update for adult use, particularly for the retail licenses being updated from 3 to 5. And those have been made under the sections pertaining to the general requirements for marijuana establishments under 500-050, including sections pertaining to control limitations and marijuana retailers. There is the social equity business exclusivity period, which is 12 months for that 6th additional retail license, which has been added under the marijuana retailer section under the general requirements for marijuana establishments in 500-050. And this 12-month exclusivity period will begin when the commission begins accepting applications for these additional 4th, 5th, and 6th retailer licenses. The last addition for license caps is in the medical use regulations, and that is particularly pertaining to fully integrated medical marijuana treatment centers, which is a new statutory term. This, what I'll call the new acronym, FIMTC, is what we now have as vertically integrated MTCs. So those existing MTCs will now be known as FIMTCs. And in the fall, for our policy round that will be upcoming, the board will need to consider how it would like to break down the medical program for that vertical integration. So the board will be able to build out any new license types or build up any that are currently existing. With that note, the license cap for FIMTCs is 3. And if a person or entity holds 3 FIMTC licenses, they're not eligible for any other medical marijuana establishment licenses. And that's all, again, contained under the 501-050 general requirements for medical marijuana establishments. Any questions as to the license caps and social equity business exclusivity period?
Commissioner?
I have one question. It's more of a, I think, clarification for the public. Just want to, I'll phrase it as the question just for clarity. If you currently have a medical license, you do not have to make any change at this point because you're already fit within the, what you say, FITC category based on the definition. So these changes that we're making or are going to send to a regulatory comment period it's not going to affect anyone's license or renewal at this point.
Exactly, Commissioner. Thank you. Any other questions?
Commissioner Dillabato? Nope, proceed.
Perfect. Thank you, Chair. The next category of amendments are pertaining to license cap carve-outs for ESOP trustees. So this was a statutory exception for the license cap count. So persons acting solely as a trustee for an ESOP have been added under the general marijuana establishment and medical marijuana establishment requirements sections. This carve-out pertains to those trustees who are solely acting as a trustee. So a trustee that is otherwise exercising direct or indirect control would not qualify for this license cap carve-out. We've taken mainly the statutory language very directly and added that to both sections. Any questions on this license cap exception?
Commissioners? Nope, proceed.
Thank you, Mr. Chair. The next license cap carve-out is for those persons or entities holding less than 20% equity who do not otherwise have direct or indirect control. So these amendments for the license cap carve-out were for persons, again, possessing less than 20% equity, and again, not having that direct or indirect control. And these have been specifically amended through our definition section, specifically for the defined term of owner, which has been updated to reflect, instead of a 10% equity interest holding, a 20% equity interest holding. That has also been updated through our person or entity having direct control. And so that definition has been updated to reflect the new defined definition of owner. Any questions pertaining to this carve-out?
Commissioners?
No.
Nope, proceed.
Perfect. So the last category is for equity holders possessing an equity interest of 10% or greater. With the change of the amount for equity that counts towards the license cap to 20% or greater, so long as there's not otherwise direct or indirect control, the commission needed to add some additional language to comply with other statutory mandates, particularly in 94G Section 5 for those background checks that we discussed at the last public meeting. So the statute mandates that the commission perform reviews and background checks for persons or entities possessing 10% or greater equity in a license. And therefore, the commission needed to add some additional language to capture that group of people, the 10%ers. So you'll see throughout both 500 and 501, the phrase equity holders possessing an equity interest of 10% or greater. And that has been added in all of the relevant places that's necessary to maintain the status quo for all requirements other than what's counted for license caps. And so you'll see it in sections for the application requirements, background checks, independent testing laboratory and responsible vendor trainee requirements, record keeping, enforcement provisions, and suitability requirements. Any questions as to this section?
Commissioners?
I just have a comment. Thanking for the process and all of this, because I know I really stress a lot on wanting to make sure that that our wording was capturing those new 10%ers, and this will allow for us to both track. And then just, again, we talked a lot about data last week, and we'll just put that out there again, our due diligence, and making sure that we are watching just behavior now that there's a larger amount of people that will have equity, interest and incentive in that space. So this is really just for all of us, to make sure that we're thinking through. And I do know that we're required to make sure that we're looking, at this within the first or within 12 months or something like that, correct? So with that requirement, I do encourage us to start thinking through what that action plan will look like from a data perspective, so that whether it's like quarterly revision, et cetera, maybe we need to change up how, certain data sets, but wanting to make sure that we're mapping that out in advance.
Thank you, Commissioner. Commissioner Wilson?
I have a brief comment. I just wanted to, at our last meeting, Commissioner Dillabato did raise, when this came up, did raise the issue of the potential negative impact on social equity participants based on this rise in licensing caps. And after that, and I was thinking about those words in the week since, and I've heard stories and have had some conversations, particularly around predatory lending, and people sort of in the background trying to hoover up licenses through the cap process. So, or sorry, through the equity process. So I just want to say that I heard you. I think that you raised, and I think it's something that, to your point, we should, not related to this, but sort of moving forward, be doing some things around sort of tracking how many licenses people are a part of, even if they're well below the limit. And I think that's something that we can't work with directly, but maybe through our teams with the staff, because I'm on the license cap and ownership side, and you've got the social equity side. I think that there's some real important work to be done there. So I thought that was a really important point you made, and I want to work with you on it.
Very good points. I think we're good on that one. So, legal, any other thoughts?
All right, so we've covered all of the categories of amendments in the draft red line package. And so, Mr. Chair, there are 3 motions that we have presented for your review and consideration on that package.
Yep. So, yep, there were 3 motions. Let me read this and see if we have a second and if we can move toward improving. So the first motion to approve the draft emergency regulations at 935 CMR 500.000 and 935 CMR 501.000, resulting from commission deliberations, including all amendments to increase possession and sale limits from 1 to 2 ounces, license cap updates and social equity business exclusivity period, and license cap exclusions for ESOP trustees and persons or entities possessing an equity interest of less than 20% who do not otherwise have direct or indirect control, as final for submission to the Secretary of the Commonwealth. There's a mouthful. Thank you, legal. So I think we all know the substance here. We've talked about the context, emergency regs, and then moving toward the regular promulgation process. But on that motion, do we have a motion to approve?
So moved.
We have a second?
Second.
Roll call, Commissioner Delabato.
Yes.
And Commissioner Wilson?
Yes.
And Chair, yes. So moved on motion 1. Okay. Motion 2. And this is around allowing staff to make ministerial edits and file with the secretary. So, motion to authorize commission staff and the legal department to make any ministerial edits to the final emergency regulations at 935 CMR 500.000 and 935 CMR 501.000 that are consistent with commission deliberations and votes, the commission's governing laws, and the Secretary of the Commonwealth's requirements, and to take any additional steps to file the final emergency regulations with the Secretary of the Commonwealth. And again, this is ministerial. This is just making sure that we're efficient and we can get these things in on time. Do we have a motion to approve?
So moved.
Do we have a second?
Second.
Roll call, Commissioner Delabato,
Yes.
Commissioner Wilson,
Yes.
Chair Harding, yes. So moved on motion 2. Motion 3, approve the staff to file notice of public comment and hearing, which we've also talked about, which is important. Motion to authorize commission staff and legal department to take all steps necessary to submit a notice of public comment and hearing on the final emergency regulations at 935 CMR 500.000 and 935 CMR 501.000 with the Secretary of the Commonwealth. Do I have a motion?
So moved.
Second?
Second.
Roll call, Commissioner Delabato.
Yes.
Commissioner Wilson?
Yes.
Chair Harding, yes. So moved. All right. And unless there is other business, and I'm going to look at the executive director.
I just want to make sure that we're noting next steps for the public. Obviously, we've gone through this with commissioners. So I believe we have a slide on the timeline. Would you like to go through that? Would you like me to? I'm good either way.
I'd be happy to do that, Mr. Executive Director. And so thank you very much for noting that timeline. Now that we have the board's official vote, so this timeline will be very much in play for all of our next steps. So as you know, the board voted today to approve those emergency regulations. The legal department will be filing those with the Secretary's office tomorrow, along with a notice of public hearing and comment period. The public comment period will begin on July 3rd, which will run through July 30th. And we will also have our public hearing on July 30th as well. On August 28th, that would be the deadline for the commission to file any final amended regulations for this emergency package, where publication of those updated amended regulations would be made on September 11th, and those regulations would be made permanent as long as we comply with this process.
Commissioner Dilibato.
Quick question, just out of curiosity also for the public. Once we start collecting public comment, how does the public submit those comments?
If I may, Mr. Chair. So the
Please
public
do.
is able to submit through email, submit written comments. This has been something that I think many of our engaged stakeholders have been very aware of, but they're able to submit anything they'd like in writing to us. I believe this time it will just be through email. That's what our notice will state, is that they can send us through email. Of course, they can send something in the mail as well if they'd like. And they're also able to testify on the day during the public hearing. And my understanding is that will be in person and with a hybrid option. So if anybody would like to testify, they have those capabilities to prevent somebody from necessarily having to drive down in person or miss work. So the board will be able to hear from everyone who has interest. And then those comments and testimony are compiled for the board's review and for staff to work through for any potential amendments that would be beneficial.
Thank you.
Terrific. Commissioner Wilson?
I have no questions.
All right, so we have the timeline. So it's going to be a busy summer. And, you know, we appreciate you, legal team, because we know you're going to be working very hard, but this is such an important part of the process. And getting that public comment and testimony is just critically important, especially since we're moving very quickly based on the Chapter 65 guidelines. So in any event, Executive Director, anything else that we're missing here?
Thank you, Mr. Chair. I would just note again, I know we discussed this quite a bit last time, but just for any public just tuning in for the first time saying, hey, these emergency regs, you guys are moving quick. That's so great. These are the things that we are doing in line with how the statute is written. And obviously, as you just noted, it will be a long year of regs, and all of the other priorities of you all as commissioners will be coming through in that process. So thank you very much for taking this approach and getting up to speed so quickly on something that obviously was a timeline handed to you and us. And thank you as well, obviously, to the staff that was able to turn this around as quickly as they did, and to keep us in compliance with the statute. So thank you very much.
Terrific. Any final thoughts from commissioners?
No.
Well, first, just want to thank staff. I mean, a ton of work has gone on here, and I hope everyone appreciates that. So thank you very much. And thank you, commissioners. I'm going to note, by the way, that this meeting was 2 hours and 55 minutes with a few breaks. So I think we're moving with haste, but also with purpose. And I appreciate you both. Thank you very much. With that, we have a motion to adjourn.
So moved.
Second?
Second.
All in favor? Aye.
Aye.
Roll call. We are adjourned. Thanks, everyone.